We planned this conference with intention, so our panel really dovetails well with the last panel, sort of a look forward on housing. And I also want to pick up on the kinds of comments that Attorney General Rosenblum was sharing with you to say that there are a lot of ways to have opportunity. As a young lawyer, my associate, Stephen Thorpe, worked on a resolution about the affirmatively furthering fair housing resolution that's included in your materials tomorrow with Peter Buxbaum, another section member, and myself. And so we got that resolution passed by the House of Delegates through our section, which was great. And then here locally in Portland, I'm on a board that Ed Sullivan co-founded, the Housing Land Advocates. And there's a couple of young lawyers here, Caleb Hugel and June Bradley, who are volunteering currently or have volunteered with the HLA in the past. So with that, let me introduce the speakers on this panel, Housing Policy to Combat Modern Exclusionary Practices. First, we have Professor Jennifer Thomson of Bucknell University in Pennsylvania. She holds the National Endowment for the Humanities Chair in the Humanities, and she's an Associate Professor of History. Professor Thomson specializes in the post-1945 history of the United States with particular concentrations in health and the environment and structural inequality. She is the author of The Wild and Toxic American Environmentalism and the Politics of Health, and her current research examines how the United States Environmental Protection Agency furthered the racialized health inequalities and environmental hazards generated by federally sponsored residential segregation. So that really picks up on the redlining conversation that Sarah started with us in the last panel. And then we have Ed Sullivan, who is my mentor and friend and the person who got me involved in ABA all those years ago. So thank you, Ed. It's great to be up here with you. He is a retired land use lawyer who specialized in that area of practice for over 45 years. And before going into private practice, he served as the assistant county counsel for the county of Washington County, Oregon, and as legal counsel to the governor of Oregon. And over the course of Ed's career, he has taught and mentored countless law and land use planning students, including myself, as well as published a body of work that aims to explain land use law in Oregon and beyond. And so on the Board of Housing Land Advocates, he looks at the intersection of land use and the provision of affordable housing. And then our last panelist is going to give us some grounds for optimism. This is Allan Lazo. He is the executive director of the Fair Housing Council of Oregon, a statewide civil rights organization founded in 1990 whose mission is to end housing discrimination and ensure equal opportunity to housing. FHCO provides access to education, enforcement, and public policy advocacy. We have a joint project with Housing Land Advocates and Fair Housing Council, so Allan's become a near and dear friend through that work, and it's through his engagement that he was recently appointed to the Land Conservation and Development Commission, our state agency that governs Oregon land use, and so we're so happy to have a housing champion on there. So thank you, Allan, and thank you, all of you. I'll turn it over now to Professor Thomson to start us off. Thank you.
All right, thanks for the introduction. Hi, everybody. Thanks for having me. This is my first time speaking to a group of lawyers, so I hope you don't come to regret inviting a historian to join you for your conference today. So today I'm going to talk about the historical relationship between housing segregation and infrastructure, specifically by thinking about the role played by the U.S. EPA. Okay, so specifically how the U.S. Environmental Protection Agency chose to allocate its funding in the first decade of its existence, which anybody who has even a passing familiarity with the agency knows was its only decade where it actually had a chance to make any significant changes in federal environmental policy, right? Once Reagan was elected and the massive rollback in funding as well as bureaucracy happened, it was very difficult for EPA to ever recover from that. As part of your CLE materials, I circulated a hopefully relatively brief, recently circulated article on these matters, and I'm happy to talk about any of the details of that in the Q&A, but today I'm going to keep it a little bit more broad strokes than what was in that material. So specifically in my time today, I'm going to focus on how environmental protection and residential segregation are mediated through the reality of the United States as a nation that was founded upon and continues to practice white supremacy. In particular, EPA ended up practicing a form of environmental protection which is very entrenched within the United States, which is one in which benefits primarily and in many cases exclusively accrue to white homeowners. And EPA, we certainly know the longer history of that, and EPA, beginning with its creation in 1970, was not any different than other federal bureaucracies. So EPA was charged, of course, with protecting the health of what was referred to as the entire ecological chain. And we have to consider that one of the central pieces of such an ecological chain is residential segregation as a primary cause of ill health in this country. EPA's failure to intervene in its 5 decades has contributed, of course, to the purposeful degradation of water systems, obviously Flint, Michigan being a huge example. We can also think about the collapse of the infrastructure in Jackson, Mississippi recently, as well as the continued success of suburban efforts to use environmental protection as a proxy for residential segregation. Right, and I'm sure you're all familiar with different examples of that happening, right, where homeowners use arguments about open space, environmental amenities, actually as a way to exclude people they don't wish to have living in their community. And EPA's practices helped that gain traction. Okay, so environmental activists and scholars have compellingly documented the way in which polluting and toxic facilities have been placed in poor and minoritized communities. So I'm sure you're all familiar with this. This is the cover of the 1987 UCC report, right, which was really the first comprehensive study of the way in which toxic facilities were deliberately located in minoritized and poor communities, particularly Black and Native communities. The subsequent scholarship has focused on how federal policy, zoning, and NIMBY activism intersected to reproduce disparate patterns of exposure and demonstrated the cumulative health effects of this infrastructural redlining. So again, this is a study which came out earlier this year, which was definitively showing that redlining has led to increased exposure to air pollution for communities who were zoned in C and D neighborhoods. Okay. Now, this well-established analytical framework gives us a basis upon which to start to consider access to sanitary infrastructure as also an issue of environmental justice. Okay? So the EPA's Municipal Wastewater Treatment Works Construction Grant Program, typically given this gigantic name, which was created in 1972, functioned as the nation's largest public works program until its dismantling in 1987. All right, so this was the program through which EPA allocated billions of dollars in funding to local communities for either the construction of new sanitary infrastructure or the revision of existing infrastructure. Okay. Of course, as we can imagine, this had immediate relevance for patterns of residential segregation. If we back up a bit and think about the 20th century more broadly, in the first 2 decades, many American cities had responded to recurrent outbreaks of things like typhoid, yellow fever, and other, especially waterborne diseases, by extending water and sewer infrastructure to all residents in a manner that was surprisingly relatively irrespective of race or class, right? Obviously, that's not, it wasn't an egalitarian move, but if we look at the distribution of infrastructure, it did reach the majority of residents. However, in the immediate post-World War II period, the rapid suburban expansion of the United States put significant stress on the existing infrastructure. Rapidly expanding suburban areas continued to demand access to municipal infrastructure and often refused to pay for any kind of upgrades or regular maintenance. So these 2 images are a little bit small for you. I'll just talk to you about what they are briefly. Okay, so the image on the top is from Detroit. The image on the bottom is from Cleveland. And these are looking at, so the areas that are outlined are the areas of the actual municipal area. And you can see all of the suburbs beginning to exert a demand for service. By the 1960s, many cities were increasingly less integrated as a result both of federally sponsored residential segregation as well as white flight. Okay? With declining tax bases and increasingly limited access to federal funds, these cities were also increasingly less able to maintain their aging infrastructure. Right? So the pressures are coming from multiple locations. Racial inequality and access to public services worsened. And by the 1970s, minoritized communities were significantly less likely to be connected to public sewers. To add insult to injury, water and sewer systems constituted one of the most crushing expenses for municipal budgets. Construction costs were exacerbated by inflation, which was growing rapidly at the time, and states often distributed federal grant money to non-urban communities while the federal government targeted cities for enforcement. Okay? So cities like Detroit and Cleveland faced increased federal scrutiny over water pollution, while at the same time they incurred significant debt as they attempted to modernize their sanitary infrastructure. So EPA's wastewater treatment construction grants were obviously vital for these communities seeking to improve both human health, but also to address environmental issues. Yet the way that they were conceived and allocated mirrored larger patterns of racial discrimination and urban scapegoating. So to think about this a bit, I'll just look for a minute at one of EPA's first actions. Right, so this is the first administrator of the EPA, William Ruckelshaus. On December 10th of 1970, Ruckelshaus, who was administrator of the then only week-old EPA, addressed the 47th Congress of the National League of Cities in Atlanta. And so this is basically a conference of mayors down in Atlanta. The previous day, Ruckelshaus had served 3 majority black cities, Detroit, Cleveland, and Atlanta, with 180-day notices for violating federal water quality protection standards. Should the cities fail to negotiate with EPA in a timely manner, they faced injunctive action from the Department of Justice. And so speaking at a joint press conference with the 3 mayors, Ruckelshaus portrayed EPA as taking harsh yet necessary action to catalyze the cleanup of the nation's waterways. Right? At the same time, Carl Stokes, who at the time was mayor of Cleveland, decried the administrator's action as a cheap and tone-deaf political move, saying the following: not only does he suffer from an ignorance of the facts as it relates to the city of Cleveland, but he conveniently ignores and blandly avoids the outrageous, atrocious failure of his federal government to put a dime into Cleveland's sewer program. After describing Cleveland's own years of efforts to upgrade its water pollution control systems without any help from the federal government, Stokes declared that the people of Cleveland would not continue to be the federal and state government's whipping boy for their malfeasances. So we see 2 things going on here, right? On the one hand, Ruckelshaus is portraying EPA's punitive intervention as somehow cooperative, right? Some kind of attempt to get the city to comply. And on the other hand, Stokes responding with really legitimate vitriol for Ruckelshaus and the EPA, deliberately ignoring the historical lack of funding faced by cities, the strain that had been placed on urban infrastructure by rapidly expanding suburbs, state government's direction of federal funding for infrastructure away from the cities, and the disproportionate impact therefore shouldered by the largely black taxpayers comprising the growing majority of these cities' populations. So obviously no one at the press conference could have known this, but that conflict and that encounter really foreshadowed what would plague the EPA's actions in its first decade. Okay? So obviously the construction grants could have been a potent means for remedying a public health crisis, right? They were also a potentially effective means of enforcing federal civil rights law, right? Specifically Title VI of the 1964 Civil Rights Act and Title VIII of the 1968 Civil Rights Act. Yet EPA repeatedly chose not to enforce its authority under those provisions to withhold funding from communities discriminating in public works access. Time and again, it awarded grants to communities who were in fact actively practicing exclusionary zoning. So a mere 6 months into its existence, EPA was already drawing fire from all kinds of groups: fair housing lawyers for sure, urban planners, other agencies like HUD, public advocates, nonprofits, and its own internal consultants for disproportionately awarding sewer grants to new developments, undeveloped areas, and localities with exclusionary zoning on the books. These commentators allege that EPA's allocation of grants not only contributed to suburban sprawl, but worsened racial segregation and environmental damage. So I will give just 3 examples of notable cases here. In 1974, the U.S. Commission on Civil Rights pointed to several specific examples, in this case in Connecticut, in which EPA had awarded grants to towns in Connecticut whose zoning ordinances explicitly excluded low-income housing. All right, so Glastonbury, Darien, and Avon. Also, in 1974, EPA co-commissioned with HUD and the CEQ several reports examining the relationship between its own sewer grants and segregation. The most damning of these was Interceptor Sewers and Suburban Sprawl, which concluded that EPA's grant program negatively affected land use by encouraging low-density development, specifically noting that more than 50% of EPA's grants had gone to communities which hadn't yet developed their land at all, right? A huge indicator of suburban sprawl on the horizon. The report also noted at the end that clearly EPA is funding the future development of vacant land on a large scale. Okay, the third example I'll give you is one taken from one of your members. So in May of 1977, Peter Buxbaum, who at the time was Assistant Deputy Public Advocate with the New Jersey Department of the Public Advocate, critiqued New Jersey's DEP, right, which is directly responding to EPA's own regulations, noting how DEP used zoning-based population measures to develop its own priority lists for awarding EPA grants. Buxbaum alleged that by relying on existing zoning patterns, DEP was confirming a, quote, local bias against intensive multifamily development, with specific reference to DEP's sizing of collector lines in a particular township. Buxbaum described how the enshrinement of existing zoning there as a measure of expected population will result in a sewerage plan that destroys the viability of an attempt to seek zoning changes which will permit a proposed low and moderate income housing project. All right, so the EPA is getting feedback from all of these different venues that its grants are causing harm, right, that they're reproducing existing patterns of harm. However, despite this mounting criticism, EPA doggedly refused to change course. Instead, it chose to follow a well-established bureaucratic path of conducting studies and convening task forces in order to continue with business as usual. And again, I'll just give you a few examples of a very lengthy history. So again, in 1974, coming back to these studies that EPA co-sponsored, it voiced public support for these studies, right? So it, in its own publications, talked about how their conclusions were valid and important, but internally, it worked very hard to undermine these. Okay, so shortly after the release of Interceptor Sewers, as well as another report, EPA convened a study group to review the evidence. And this group concurred that EPA did sewer vacant land, yet claimed that, quote, the amount of vacant land sewered is not a crucial element of the problem. In fact, the group contended sewering vacant land was integral to regionalization, and the agency had only a, quote, supportive or complementary role in matters of local development. All right, so from that point, that was basically the death knell for EPA to do any internal rethinking of its own interventions. In November of 1977, the administrator formed something known as the Task Force on Minority Business Enterprise and Other External Civil Rights Issues, which was intended to not only review EPA's compliance with federal minority business contracting regulations, but also to engage in a thorough review of EPA's compliance with Title VI and Title VIII. Whereas EPA completed the first half of that study by 1978, in the subsequent 2 years, it basically refused to investigate the agency's compliance with Title VI or VIII. Now, in May of 1978, Deputy Administrator Barbara Blum admitted that, quote, EPA's sewage treatment construction program has unquestionably contributed to the underwriting of suburban sprawl in some metropolitan areas. Yet, of course, this was too little too late, right? And again, continue this pattern of making public acknowledgments of either wrongdoing or of fact, and continuing to retrench on larger administrative patterns. Now, it's worth noting as well that EPA's internal mechanism for enforcing civil rights, which was known as the Office of Civil Rights and Urban Affairs, was perpetually under-resourced. with high turnover and low institutional memory. That particular office is now the basis of the Office of Environmental Justice, which I'm sure some of you interact with. So ultimately, rather than seriously evaluate its civil rights obligations and the role of its own grant program in reinforcing and encouraging racially segregated suburban sprawl, EPA chose to engage in years of bureaucratic theater. The consequences of this choice were profound. Housing development inevitably followed the construction of sewer infrastructure, and cities that were unable to finance the necessary maintenance or upgrades of their own infrastructure slid further into debt and became increasingly less able to provide their residents with a healthy environment. The agency gave lip service to mixed development and the urban environment, all the while shuttling its grant money towards both suburban as well as rural areas. Okay? EPA knew very well that functioning water and sewer services are vital to the livability of municipalities. It knew of the extreme expense involved in their maintenance, renovation, and construction. It also knew that its grant program had a profound impact on patterns of racial segregation that were baked into patterns of land use in the United States. However, EPA chose to interpret civil rights as something it might opt into at its discretion, rather than as a matter of legal obligation and/or historical responsibility. In so doing, it replicated a pattern of evasion on civil rights that was already well established by other federal agencies. And I'll close here with a quote from sociologist Christopher Benastia, who's argued that civil rights are cheap. When they cost too much politically or economically, they float untethered to authentic remedies that would lend real weight to them. That EPA knew of the impact of its grants, yet did nothing substantive to alter its practices, reminds us how deeply the ties between environmental protection and structural racism run. Thank you.
So thank you so much, Professor Thomson, for laying the foundation of some of the work that we are trying to undo in Oregon. And what Yvonne was saying in the last panel was, you know, travel around the suburbs of Portland and you'll see a different part of Oregon. And travel a little further than the suburbs and you'll find the urban growth boundary. And that is what keeps some compact development in Oregon, trying to control sprawl, and then looking at pressures to expand the boundary to house the lowest income people. So pushing them out from the good quality neighborhoods, close to jobs and things like that. So Ed, take it away and tell us what we're doing here in Oregon.
All right, thank you. The thesis of my presentation is we've done a little bit to move around the allocation of housing, and that allocation of housing is now moved towards racial and environmental justice, and we may even have a chance of succeeding because we're building upon an existing system which has existed for 50 years. As of next year, and sets up a structure in which state policies can be realized at the local level. My presentation is assisted greatly by two members of this section, Sarah Adams Shane, who spoke at the previous panel, and Caleb Hugel, who is the staff attorney for Oregon's Land Use Board of Appeals. And the three of us worked on a presentation to talk about what Oregon has actually done in the field of housing justice. So you all know where we are. We're up in that northwest corner of the United States on the left coast. And we have a long tradition of backing up planning and land use regulation and trying to make sense of it. So briefly, what our state land use program for the last 50 years has done is to set up a commission which actually drafts and implements state land use policy. This is not your standard zoning enabling act jurisdiction, all right? Where all of the ability to plan and zone is just delegated the hell out to cities and counties. They do what they want, and the courts take up any disputes. That's not where we are in Oregon. We have a state commission which has established 19 statewide planning goals. These are binding policies that local governments must incorporate in their local comprehensive plans. And because we also have a long-standing tradition that comprehensive plans govern zoning and other land use regulations and actions, these goals mean something. This commission not only adopts these policies, but they also enforce them. They review plans, they take up any potential violations of plans, and they have the ability both to command that plans and regulations change, and also, maybe more importantly, to withhold state funds from those recalcitrant cities and counties that don't do the job. All right? As a result, we have built into the wallpaper a system in which state policy can readily be applied at the local level. We have this review of plans called acknowledgement. We also have a periodic review, and also a review of individual plan amendments upon an appeal to the Oregon Land Use Board of Appeals. And I've given you a little pyramid here, which shows how land use actions are built upon the various other parts of the structure, starting with the state and federal constitution, then continuing into statutes, and then these 19 binding statewide planning goals, which run the gamut of procedure to individual areas like the coast. One of those goals has to do with housing, Goal 10, and I'll talk a bit about that in a minute. All of the goals, or all of the important goals, have administrative rules, which LCDC, Allan is our representative here from LCDC, can amend and fill in the details. So it can get awfully intrusive, much to the discomfort sometimes of local governments. After that, we have the plans. Once they're acknowledged, they combine all those statewide planning goals into the basis for land use regulations and then the individual actions. Okay? So all of these things are comprehensively put together. Now we've done some other work here. The Oregon legislature in 2019 passed 2 significant pieces of legislation relating to housing. I'm going to talk primarily about the first one, which is now completed in its application. And I'll mention the second one, which is likely to be completed with the 2023 session. So housing under House Bill 2001, 2019, divides the state into 3 groups of urban areas, cities being the component, the natural component for these areas. Small, under 10,000. Medium, 10 to 25,000, and large, anything over 25,000. And roughly in those last 2 categories, we have 20 to 25 cities out of our 260 cities that are involved. We also have this idea of model ordinances. We want you to comply with state policy, but if you don't, automatically kicks in a series of model ordinance provisions, which will make you do it, regardless of what the local government enacts, okay? And it also provides for us attorneys, or us recovering attorneys, with having a means of enforcing that by taking the city or the county on. We've also had an ability for those cities and counties that don't have everything together yet to get a time extension. Those times are up, but the mechanism was there. It was able to be used if you had a problem with a sewer plant or something along those lines, okay? And then we also are not overriding our natural resource and other goals, historic preservation and the like. So we're trying to accommodate middle housing. You've all heard about this now, all right? And we have special categories of middle housing, and they run the gamut from duplexes all the way up to high-density apartments. And these are, for the larger cities, now required to be incorporated in plans and regulations. The era of the exclusive detached single-family home is over for these larger cities. You got to have these other uses in there, all right? So here's what we look at. I've given you the middle housing categories in the top line. Small cities, under 10,000, all they have to do is to allow for certain housing to be added on, mother-in-law housing. But the middle cities have to allow, wherever there is a single-family detached home allowed in a zone, you got to allow a duplex. So you double at least the potential for this. And this does not require any discretionary application to do so. You have to get the building permit, of course, but it doesn't require any land use approval. So that's for medium cities, all right? For large cities, that is cities over 25,000, and all cities, there are 23 of them, in the Portland metro region, you have to have an accommodation to allow these middle housing instruments, which you see on the first line. We've codified this requirement. That's the last line in this slide. And what's happened is that there was a deadline for medium cities last June 30th, 2021. All but 3 or 4 of the 23 made it. And for those, the model ordinance kicked in. There's been no complaints about that. The cities that didn't make it said, we just can't get it done physically. So, but they're doing it because the model ordinance kicked in. For larger cities, it was last June 30th. And again, we have 2 or 3 cities that didn't make it. But no one has said hell no, all right, which is part of the culture here in Oregon. Planning is part of the wallpaper. And what the goals say and what the administrative rules say and what LCDC has done is to become a part of that. Now, here are some of the barriers that we have to deal with in looking at middle housing. The biggest one, I think Allan would agree, is parking regulations, all right? We're in a constant review of what we're doing to aid and assist. Allan and his commission just passed some wide-ranging rules for larger cities, climate-friendly and equitable community rules, which say that around the big TriMet streetcars and around bus lines that run very frequently, you can't have parking regulations that will prevent housing from occurring. Big deal. Some cities are going to appeal it. They'll probably fail, but we'll be off to the races to try to get something done. And of course, parking, as you may well know, is one of the components that adds so much expense to the building of housing. So we're there to take a look at it. Okay, so these are, again, some of the regulations. And lot sizes have a lot to do with it, all right? So when we have these regulations in place, and they are in place for the zoning part, and they will be in place next year for climate-friendly and equitable communities, we have a shot at getting towards nirvana, all right, where we have a better shot at getting housing justice and environmental protection done at the same time. So here's some of the model ordinances. You have the deadlines in the first line, and you also have a direction to the Building Codes Division to make conversions from single family to multifamily much easier, so that we can realize some of these benefits of having these more dense housing alternatives available. Okay. The Infrastructure-based time requests are all over now. We only had a couple on each of the categories, and largely everybody has at least said we've adopted ordinances. We, in our housing group that Jennifer heads, look at these and can appeal them if they're not doing the right thing. And that would go to our Land Use Board of Appeals, which has a pretty good track record of making sure that state statutes and rules are filled in. Now, there are exceptions, of course. We don't try to build on wetlands or outside urban growth boundaries. All right? We try to make sure that within those boundaries, we have a 20-year land supply that will take care of the future needs of all kinds of housing for owners and renters. We've had some problems with the city of Eugene, and you can see the litigation up there over how that city complies with some of the housing requirements. They threw in a few regulations which tended to discourage the kind of housing that we want. They were taken up 3 times, and the city has finally complied. Okay, so we're now there to assure that housing occurs. Here's the timelines. The timelines have been met. LCDC has done its job, and local governments, to their credit, have done their job as well, at least on paper. And all of this is supposed to be against a background in which housing, unlike any other use, is generally supposed to be accomplished under clear and objective standards. All right? None of this crap about the character of the neighborhood. Okay? So we have a shot at doing this, and we have a shot because our planning culture allows for cities and counties to do the right thing, and to do it because it's expected of them politically and socially. Whether we get there, we'll see. Just one other thing I want to talk about before I end. There's a companion bill that occurred in 2019, House Bill 2003, which sets up a new structure in which the state will allocate out, not only project populations for urban areas, but allocate the kinds of housing that are needed within each urban area. Okay? And it also has a system in which Allan, he's going to be really pushed hard, and his colleagues are going to have to deal with recalcitrant cities, recalcitrant urban areas, because the Department of Land Conservation and Development is supposed to look every 6 or 8 years, depending upon the city and its population, at how they're doing with reaching the targets that are set out for all kinds of housing. And if they don't do the job, there's a graduated system of enforcement ranging from, let's talk, to we're going to withhold your money, which does get their attention, to assure that those targets are met. We're not at nirvana. We don't know whether this will all work together or whether there'll be a political reaction. But it's sure as hell better than what the rest of the country's doing. Thank you.
Thank you, Ed. Really wonderful presentation. I will say my private developer clients love House Bill 2001 and middle housing. They're looking at all kinds of opportunities. I know an architect who left his big firm to start to do infill duplexes. But that is what it's creating. It's creating market rate housing. So if it's affordable, it will be because density happens and because market rate rents drop. And so House Bill 2003 that Ed mentioned at the tail end is really where my hope is in terms of affordability, because it sets targets, it ties things, and if Allan can convince his group up there at LCDC to tie some of the incentives to true affordability at the lowest levels, we might start to serve all income levels, which is sort of the planner's dream here in Oregon. So Allan, we'll let you combine your Fair Housing Council work with your role on LCDC and give us hope for the future.
I actually thought I heard optimism in Ed's presentation either, so I think I'm not the only one here optimistic about what's happening here in our state and I think in our country. So Jennifer, thank you. Professor Thomson, Ed, thanks so much. I really appreciate the opportunity here to broaden our perspective on this work and really kind of go back and talk about why what Professor Thomson talked about and why what Ed talked about matter here, and really look at this connection between what Professor Thomson brought forward about systemic EPA civil rights violations and what Ed brought forward around efforts to end exclusionary single-family zoning here in Oregon and other parts of the country. And I go back to Ed's graphic actually here with the pyramid, because what I'd offer is one of the places that we often don't think about and talk about enough is actually the bottom layer of this pyramid of Ed's, right? Underlying all of these concepts and these actions is this history of historical inequities that Professor Thomson touched on. I'm going to touch on in the housing context, and it really is the basis for not only the laws, the policies that we set, but the actions that we need to take moving into the future. So we know that there are numerous of those systems that historically have worked to create and perpetuate, for me, particularly racial residential segregation, and then are further linked to continuing inequitable outcomes today for certain communities, and calls for all of us and all of you as young attorneys, as civil rights and social justice and state and local government practitioners to act intentionally to remedy those disparities if we are to tip the scales toward true housing justice. Now, I know that's a lot of connections to make, so you'll have to give me some latitude here as we move forward, but I think we're going to get there by the end of this. And so let me switch over to my actual presentation. And I think, what I'd offer is to envision this pathway. I'd offer this framework about how many of today's inequities that we see kind of on the outside of this circle have evolved or radiated from this central set of racist housing policies. Again, I'm going to talk about it from, that's the world that I work in. It's the world that the fair housing world is based in. But we can clearly see these connections in many, many different areas. So in housing, we know that there are not only the exclusionary land use and zoning policies, but financial disinvestment like redlining. It seems like you all have been talking about redlining a lot for the last couple of days. So I'm going to touch on it here, so we may not have to talk about it too much. But again, at the center of this framework are these historical racist housing policies that radiate out into racial inequities that continue to have impacts today and to which we must respond further with intentional actions to remedy. One of the things that, as I just said, that really strikes me about these when I enter into these conversations is the breadth of impacts that we see that are born from those central policies, as well as the interrelationship among those inequities that we see in that outer ring, right? When we talk about everything that's happening in the world over the last couple of years, we talk about racial injustice, police killings, COVID-19 inequities. They're so interrelated and emanate out from that central piece. So, we could take Professor Thomson's work on the EPA's role, and we could, use that as another example here. But we're going to talk about a couple of examples in the housing world that really connect that direct through line and radiate out from those central policies. And I would really encourage you all to continue exploring others, and I think that there are a lot of folks in this room, it feels like, that are really doing that, and find ways in your own work to think systemically and to act intentionally. If you haven't read or are not familiar with Richard Rothstein's book, The Color of Law, its subtitle is A Forgotten History of How Our Government Segregated America. It's an entire book about those policies and practices. Even for me in the fair housing movement, it was amazing to read an entire book about it. We've also seen a real shift in lots of places towards this conversation. Right here in Portland, the Bureau of Planning and Sustainability put out its own report about its role in the historical context of racist planning. Down in the Bay Area, from the Othering and Belonging Institute, you've also seen reports on historical racial discrimination and its role in segregating communities and increasing the lack of housing supply in the Bay Area. So again, to follow a couple of these through lines from these past racist housing policies to continue inequities, let's start at the center and talk about the details of some of these cascading or radiating impacts, and then furthermore, the remedies, I think the optimistic part of where we can head today. So certainly one of these histories that we need to examine is what we traditionally today think of as the American dream, right? And recognize that this ideal that has been normalized as single-family home ownership in the idyllic suburbs actually is rooted in a history of racial segregation. The city of Baltimore, for those who may not be familiar with this racialized history of exclusionary single-family residential zoning, in the early 1900s, there were cities across the country that instituted land use zoning rules that explicitly excluded residents by race, particularly black residents. The first to do so here on the screen was Baltimore, which in 1910 had this ordinance that prohibited African Americans from buying homes on blocks where white residents were a majority and vice versa. In 1917, however, of course, the Supreme Court ruled that practice to be illegal under Buchanan versus Worley, and their ruling actually was based on that those racial zoning ordinances interfered with the right of private property owners to sell to whomever he or she or they please. So that was actually the basis for those kinds of rulings rather than a social justice framework. But this ruling by the Supreme Court then gave rise in the early part of the 20th century to the nefarious practices nationwide of land use zoning that utilized proxies for race, namely economic status as a means of exclusion in the form of single-family residential zoning. So as we kind of move out to the edges of this, we see here in Portland, these are actually the first zoning map that was created in Portland in 1924 that created the original single-family residential zone. There were 15 single-family residential zones that were created by request of property owners in these neighborhoods. Now, I think lots of folks are not from Portland here, so you may not recognize these areas, but we also know that this dynamic occurred across the country and will be familiar to wherever you're from, is my sense. Now, here in Portland, whether or not single-family residential zoning, this map was created intentionally to exclude by race, whether or not that's the case, it certainly was created in that atmosphere when that was the predominant thinking across the country. And even if the explicit intent wasn't racist and exclusionary, the impact of exclusionary zoning certainly has had that outcome right here in Portland, from an economic standpoint, and of course, by extension, a racial standpoint. So let's take a look at a couple data points that highlight how this historical policy has perpetuated those inequities right here where we're sitting today. Here we've overlaid, or the folks at Sightline have overlaid those in yellow, the 15 single-family residential zones, the original ones in Portland, over the highest income tract groups here in Portland. And of course, you can see the close relationship that exists between those. Similarly, again, if we add another one, if we overlay there's the 15 original zoning plan from 1924 with this population by race in our city, you can see that historically exclusionary nature of single-family zoning, where the darker areas are the highest population of the white residents here in Portland. And so that's kind of, in part, the subcontext for what Ed talked about. It's really been interesting to kind of watch the evolution of how this narrative about the history of racially exclusionary zoning has played in these efforts to eliminate single-family zoning, right? And when I say interesting, it's interesting from the perspective that these efforts have sought to address these systemic issues, but in some cases have not been able to capture intentional action to directly remedy the inequities created. I think what Jennifer said was really profound, right? We don't yet have actions that actually address this history. When you heard Ed talk about it, there wasn't anything in there that really addressed that. Even though the conversation was about that and there was an underlying intention to do that, there's nothing in what is in House Bill 2001 that begins to address that real inequity. That was true for Minneapolis, same thing. I was involved in conversations and presentations with folks from Minneapolis 3 years ago, and that was the exact same thing. And so what we see in these conversations is the intent to address these inequities, but not the actions that actually do it. There's this sense that by ending single-family exclusionary zoning and increasing supply, it will automatically do it. But we know that that pathway has not always worked out for those communities who have been underserved, under-resourced over time. So we need to be a little more intentional when we do that. So again, We also know that, as we talked about Minneapolis there, and we know that, again, that these exclusionary land use practices, including other dynamics like redlining, have resulted in, oops, sorry, I touched the thing, have resulted in persistent racial segregation across the country. And among those radiating impacts of racial segregation in communities is the role that it plays as an underlying cause of police violence against black communities, excuse me. The impact, for example, of redlining, racial segregation, and displacement of black communities played a role in the 2014 killing of Michael Brown in Ferguson, Missouri, as well as similar incidents in highly racially segregated communities like Minneapolis. Right? In 2020, Time magazine drew similar parallels to Minneapolis's history and the role it played in the killing of George Floyd, noting in this article that, quote, Minneapolis wasn't particularly segregated when racial covenants were first introduced in 1910. They were preemptively put in place before black people lived in Minneapolis in large numbers. Kirsten Delegard, a historian and director of Mapping Prejudice, a University of Minnesota project that has plotted the locations of racial covenants, says, you have 2,700 African Americans living in the city in 1910, and then 30,000 racial covenants blanketing the city to make sure all this land could never be occupied by people who aren't white. After they had been in place for 30 years, the city became highly segregated, and people who weren't white were sorted into just a handful of very, very small neighborhoods. Like every black neighborhood in the country, it's also been subject to over-policing and very different kinds of police practices than the predominantly white neighborhood a couple of blocks away. When you get to the edges of those neighborhoods, there tends to be more literal policing and more contention over who in public space, who can be in public space, and what people are doing. So when we look at extending this connection between historical racist housing policies through to inequities today, then we can also start to look at moving towards those intentional acts to start tipping the scale toward housing justice. As I noted a moment ago, this was part of the underlying narrative of the work that Ed talked about behind House Bill 2001 and the desire to end exclusionary single-family zoning. And as Ed talked about, the companion bill to this, and as Jennifer talked about, House Bill 2003 was actually a really important corollary from a standpoint of addressing areas of exclusion in our communities. I'm not going to go into too many details of that. I have to leave that to folks like Ed. But in that work, we've been fortunate to be part of a conversation that is really broadening beyond just the production of housing. We know that just the production of housing is not always an answer in communities. One of the elements is a set of housing production strategies that also addresses things like anti-displacement and gentrification measures in communities. So it's at least bringing forward this conversation in what had been a pretty technocratic exercise of planning for housing in our communities, which really hasn't worked out well for lots of folks. So if we reset this to another quick example here of another through line from historical racist housing policies, we'll look at the piece around redlining. Right? We know redlining was the creation of the federal government through the Federal Home Administration. It changed the way we buy homes. The practice, though, of the insuring of homes through the FHA was really based on the many racist policies and practices, including the FHA underwriting manual that ranked different races by how they were valued here. And so this was really the underwriting for FHA incorporated these types of racial segregation principles and racial biases. Those underwriting standards then were based in part on this list. And the list that had been widely used from the 20s through the 40s by real estate appraisers then gave rise to great inequities in the distribution of these loans. If you need more resources on redlining and where that occurs, and maybe in your community, Mapping Inequality is a great website. It's an interactive website. You can go and look at your community and see the redlining there. But when we look at that, the impact of FHA loans and its racist underpinnings, so what we know about the FHA is that the redlining of neighborhoods that predominantly involved communities of colors led to extreme racial and financial inequities. Between 1934 and 1962, of the $120 billion in loans made by the FHA, less than 2% went to non-whites. So again, much of that history is highlighted in Richard Rothstein's book, and is just one of the examples of these, in that case, post-Depression era programs that were intended to bring the country into a better financial place, right? Later, post-World War II institutional policies were intended to do the same. The GI Bill also had similar racialized inequitable outcomes. And these programs really were intended to create wealth-generating benefits for several generations, but left out communities of color, particularly Black and Latinx communities. Economically then, we know that the resulting inequities from those racist policies today are borne out through the racial disparities in home ownership and the racial wealth gap that further creates. So in Rothstein's book, he talks about the FHA's role, the government's role in segregating communities. The FHA underwrote large subdivisions and almost whole suburbs and required them to be segregated. So it's a really fascinating study on the government's role in what was going on then. But to return to looking at these through lines, and let's look at some of the related dynamics of gentrification and involuntary economic displacement. Right here where we are in Portland, again, this is actually a map on this kind of, we are in the lower left of this map right now in downtown Portland. The area that I'm talking about is across the river there. The darker areas show the percentage of Black or African American residents in those census tracts. Because of those dynamics we talked about, redlining, steering, all of that, this Albina neighborhood in northeast Portland, in 1990, 75% of Portland's Black residents lived in those census tracts. Today, due to involuntary economic displacement of the Black community as a result of gentrification of this area is now home to less than 25% of Portland's Black population. And we can see this graphically over time. This is the Black population in 1970. The area there in the darker brown is, in the legend, it's 50 to 64% African American. You can see because of the dynamics of gentrification pushing the community further northward. This is by 1990, it's pushed further northward and further out. And by 2000, the period between 1990 and 2000 was predominantly the period where we saw the beginning of the mass displacement, and will continue back into the 2010 and 2020 censuses as we know. So again, when we take these elements of kind of emanating out from the center of this, and we start to look at reimagining solutions, what we see on the outside part of this are solutions, things like preference policies maybe, right? And as a fair housing advocate, that's a super tight needle to thread, and so is an opportunity for the lawyers in the room to help us thread that needle. But we see one in an area in the central district in Seattle. Actually, right here in Portland, we have a preference policy in that same north and northeast Portland neighborhood that is actually very narrowly tailored to the actions of the government that took place to either take land in those areas or to displace residents that were there because of urban renewal projects. So again, another way for us to think about pathways forward from these histories is looking at community solutions themselves that are brought forward that support the growth and development of communities, such as here we have a group called the Albina Vision Trust in this picture here of the lower Albina area. This is a historical photo. So across this bridge here, you can see that there is some housing. That bridge is I'm a little turned around, but upriver from us a little bit here. It was an area that was a neighborhood, predominantly a Black community. It was that area that was highlighted in brown that we saw there. Those houses that you saw there, this is again a story that is familiar in lots of places across the country, were raised for an urban renewal project. That project was the Memorial Coliseum, where our Portland Trailblazers once played, and where now the Rose Garden is there. So that was the urban renewal project that took out houses in that area. The Albina Vision Trust today is re-envisioning that community and really looking at how could they develop a community that benefits and brings back a community that was there. We, of course, have seen conversations go significantly deeper and more intentional when we saw what was framed out in Evanston, Illinois as reparations, and that was really focused on the history of housing discrimination and racial segregation for residents there. To me, it's pretty, when we talk about reparations, that's a big conversation, and Evanston was very narrowly focused, right? And the end result of it is some housing programs. So it's interesting, that's a very tough conversation. Another way we look at reparations potentially is Bruce's Beach, right? And it was sort of interesting for me to pick up the state and local law newsletter and see the piece about Bruce's Beach on there, but that's another way forward. And it's really interesting. This is actually from the LA County government website, so acknowledging the role that government played there, so that form of land back reparations. So again, as I close, I really want us to make sure that we recognize there are many ways for each of us to play a role in tipping the scales toward housing justice by thinking about and recognizing these systems and institutions that created the underlying inequities, and then finding ways to act intentionally in your work to seek remedies. I'm hopeful that there's been a little something in here for everyone here today in this room, and specifically for those young lawyers that are here today, as a call to become the standard bearers for a new civil rights movement, and holding that intention of tipping the scales of housing justice towards remedying this shared history of systemic inequities that I know we are all so familiar with. So thank you all so much.
Thank you to all the speakers today, and miraculously covering a lot of ground in the time allotted and leaving plenty of room for questions. So I do want to open it up to folks in the audience to pose a few questions about fair housing and what we're doing. Go ahead. I think there's also, oh, great.
Thank you very much. This was wildly interesting. I really appreciate all the research and knowledge that was presented here today. I'm a landowner. I own a few rental units. And I'm wondering, what role do landlords play in a lot of the issues that we're discussing here today? I know we're primarily talking about the government's role and the impact over time, but I pride myself on trying to be a conscious landlord, while also understanding that there's a bottom line and profit realization aspect to that as well. So I would like to know, basically, what am I doing wrong in my effort to be a more conscious individual of the issues that are taking place?
We'll pass that on to Allan, who does so much work in this area.
Yeah, thank you. And the first thing I'll say is you're actually doing it right by asking the question, right? So thank you for that. The harder part, and I think if there are some attorneys in the room, the barrier that you're going to run into is that laws like the Fair Housing Act don't allow us to do the kinds of things that we might want to do to make it right. And when I talked about the call for intentional action and for young lawyers to hold that intention, it is aimed at something like the Fair Housing Act, right, passed in 1968 at a time when what we viewed as the right way forward potentially was equality. But the scales were so tipped that it is barely enough. That doesn't even take into account the politics of what had to be, the politics of possible, right? So that's really how we got to where we did with the Fair Housing Act. I don't know enough about that history to know how much intention there could have been, but we know today that we've made very little progress under the promise of the Fair Housing Act. Very little, right? Home ownership for black residents is the same as it was 50 years ago. Segregation in our schools is worse than it was 50 years ago. So you have, again, you've got the right way forward, but you've got the wrong tools. And so it's very hard, I think. The best thing you can do, I think, is ask what you can do within the parameters of the Fair Housing Act, because that's what's going to dictate what you're able to do, if I'm understanding what, or if I'm assuming what you might want to do, right? We get it very often, and it's a preference type of issue, right? As a landlord, can I dictate who can be in my housing. And under the Fair Housing Act, technically, or very difficultly, no. Right? So, but there are proxies, there are workarounds. The proxy right now for race in housing is income. And so that brings in the second dynamic that you have around, as a private property owner, the economics of it, right? So the other thing I say is we know that the marketplace and the work that we do around regulated affordable housing, the marketplace is not going to serve that. That is a role of the government. And so we need investments there. I don't think we can ask private property owners to bear that. But I think you can be conscientious. It's the best I have for you.
I would just add on a practical note, I have a friend who's a lawyer in another state, and his background is coming from a very low income place, so he intentionally renovates houses and keeps the rent very low to allow for new low income families to move in. But he balances that out with sort of a minimum, if there's a problem in the house, like a plumbing problem, then up to a certain amount of money, you're going to have to deal with that. Like, don't call me the landlord. And so there's kind of some creative ways to think about how you might structure your economics to work out in a way that would maybe support families who have a little extra but can't, in a crisis situation, but would benefit from a regular lower rent.
Another alternative, of course, is the Oregon system, which allows you to convert your one house into two or three, and be proactive in getting this done. So look at your single-family housing zones and see if you can't do something along the lines of what Minneapolis and what Oregon has done.
Other questions?
One question I had, and this kind of relates to the kind of housing and the chart that you showed, and I'm from Bellingham, Washington. This has been coming up, but I didn't see like mobile home parks as being something that's encouraged as kind of a high density, but standalone manufactured homes. And Bellingham has seen pretty rapid growth, increase in prices, as a lot of cities have because of COVID. And the city council is debating whether or not to try to protect the 77 mobile home parks that are within the city, because a lot of apartments are going up trying to meet the need, and they're surrounding the mobile home parks, and the residents are worried about what may happen if that land gets purchased. And so I was wondering how Oregon kind of approaches that, or maybe why those didn't make the cut.
Okay, early on, and this is the 80s, it's ancient history now, Oregon said that wherever you have a stick-built house, you must also allow a manufactured home. One exception is for historic areas. That's built into the system now, too. As far as mobile home parks, we still have a problem in dealing with the discretionary attempts by cities to ban them. But remember, we call them C&O, the clear and objective standards for housing. All right? So you can't say it's the character of the neighborhood. One of the cases that made my career was supporting a manufactured housing park in Tigard, which was then a very exclusive white community. And we didn't get it through, but it started the conversation. And in the 1980s, Oregon came to itself and said, if we're going to do something about affordable housing, we've got to look at the role of manufactured housing in all of this. And thank God, I think we did the right thing.
There's also other opportunities in Oregon that have to do with selling a manufactured home park and making it available to the residents to purchase before going out and selling it on the public market. So that takes some unique funding and some sophistication and the support of organizations. There's an organization called CASA of Oregon that does work around that. And then the other point I'll just leave with is Ed mentioned Tigard, in their history, but now Tigard is one of the most progressive and best leaders in our state on middle housing, on planning for housing. So it takes our young people to rise through, and we see it with the DLCD staff right now and others in this room. So, you know, remember you've learned a special language as a lawyer, and you can use it to do good in all kinds of areas, including affordable housing. So we have time for a few more questions. Yeah, Alex.
Thanks. This was a great presentation. This was extremely interesting. I live in Nevada, which has a land use system that's outdated compared to the way Oregon operates. But I also have the pleasure of being the chair of the planning commission for the city that I live in, and we're going to be improving the code in coming years. So for a place that has land use that's more at the municipal level and doesn't have these broader goals and emphasizes single-family homes, what are changes in zoning code you think would be most impactful at increasing affordable housing?
Well,
It's a
now,
good thing we have another hour for this session, huh? Go ahead. Go ahead, Ed.
start with parking. And start with minimum lot sizes. Other expectations that you have of regular housing. Do you really need these things? Or are these just add-ons that make housing more expensive? Do not an inventory, but a review of what your existing regulations do to the price of housing. I think that's a great place to start.
I would also add, you know, in your conditional use language around multifamily in particular, to excise character of the neighborhood. Wherever that comes up, I'm sure it's in your local code, given your sort of framing of this. But that is just a NIMBY bait, you know, for people to say, yeah, not here, not next to me. So, and then I would look at the middle housing model code that DLCD put together in terms of encouraging these different types of housing, especially, you said Reno, right? So you're a pretty big city for Nevada, so I think you'd have a lot of opportunity to increase density, and they appreciate the market rate element of that without too much of a heavy hand.
You know, the other thing I'd suggest is what I'm always going to go back to is I would have that first conversation about why you might need to make those changes in a tourist and service-based economy location. You know, who doesn't get to live in your city? You know, we see that here in some cities, and you know, those are folks that don't often get to be part of those decisions. But we can readily identify on the ground that they're not being served. And so, you know, one of the benefits of Oregon's land use planning system, and especially moving forward with the housing production strategy, which is this big, wide sweeping report, is going to qualitatively ask who is being served by housing. Are we actually meeting the needs, the real needs of people on the ground, not just the number of houses that you think your city might need based on what your city looks like today, right, which is a false comparison. Because if my city today is exclusionary and has 10,000 square foot lots, then it might look like in the future that I should have 10,000 square foot lots for wealthy white homeowners. But that's not the community that I think we share wanting to have. And so that's the narrative I would start with is that what we have? If not, then what are the elements that are actually the barriers to that? And what I would have said about Ed putting words in my mouth about parking is that, yes, parking is a huge piece, but it's only a symptom of the exclusionary nature of the systems that have been put in place, right? It's just one of the many symptoms of that exclusion.
All right, well, one last question. So when you require a minimum number of spaces on the lot or a garage covered spaces, it's tens of thousands of dollars to create that parking space.
Each unit.
For each unit. So then the question is, are we housing people or are we housing cars? And I think the question ought to be real clear after this presentation, what we need to house. And you want to fight over street parking, that's a different argument, but that's something we all pay for, right? It's street parking is public parking, so that's the parking issue. But there are a lot of hidden things like that. So if you have landscape standards that are really expensive, if you have certain kinds of siding that's required that's really expensive, all those kinds of things can unnecessarily add to the cost.
And don't get me wrong, I'm a single-family residential homeowner My wife and I own a home. There's only two of us. We have 2 cars, and we live, 5, 6 miles from here, and we have a garage. And I love having a garage and off-street parking. But we have to ask the question: if we are talking about housing crises in our communities, what is important to us? What are our values, right? And I think that's what we have to be asking. And so I've got to evaluate for myself: is parking my car in my driveway when my street parking remains empty all the time, and every time somebody wants to park in that, I look out the window to see who it is, right? There's a real mindset that we might need to change in the conversation we are having about the housing crisis that we're in.
All right, one last question in the back.
Yeah, so as I understand it, in the last 2 years, venture capital has bought up an extraordinary amount of mobile home parks.
Yep.
And I was wondering if there's a good model out there for jurisdictions to look at that's something the equivalent of rent regulation for that type of housing.
This is a little outside my area, but I understand that Oregon has a pretty good landlord-tenant act, and I'll defer to Allan about its application in manufactured home parks.
Yeah, and I don't know enough details either, but there are some specific pieces in Oregon to mobile home parks. I'm sorry, I don't know them well enough either. Jennifer, are you?
I don't have the data, but I can give you the name of someone if you
Yeah.
give me your card then.
And we have the Attorney General here, too, who might be able to help.
But specific and proper, and one of the frameworks we've seen around the country on that is also, which is hard to do, and one of the things actually that Cost of Oregon does is the tenant right to purchase first, right? So that's another way to potentially look at that, but it's obviously potentially very difficult for those residents to do that without assistance.
Well, thank you again to the panel and to the audience for being so engaged. It is now lunchtime until 1:15 when we